Good afternoon, everyone. Welcome to another webinar in the ongoing webinar series that firm, Garfunkel Wild TC, has been conducting in order to help out New York, New Jersey, and Connecticut clients deal with the difficult challenges posed by the outbreak of the global COVID-19 virus. My name is Andrew Swirling, and I'm here with my partners, Mary Ann Monroy, Lauren Levine, and Salvatore Puccio, in presenting today's session entitled An Employer's Guide to Facing Day-to-Day Coronavirus Challenges. For those unfamiliar with our firm, Garfunkel Wild is a full-service law firm with more than 85 attorneys serving clients in New York, New Jersey, and Connecticut that actually will be turning 40 years old next month. And pertinent to today's program, Garfunkel Wild has a very active employment law practice groups that attends to our clients' needs in Jersey, New York, and Connecticut, including through today's program. Mary Ann, Lauren, Sal, and I are partners in the firm's employment law as well as litigation practice groups. On a personal note, for weeks now, our firm has been extremely busy assisting people and businesses tackle the daunting issues relating to maintaining operational viability during this crisis. And we must admit that for the four of us anyway, what is among the most gratifying aspects of those interactions is how across the board, every employer we have worked with has made a priority of doing right by their employees, diligently to strike what we deem to be a proper balance between loyalty to their employees, health and safety concerns, and operational viability. Not a single one has made their financial bottom line the top or sole priority. And that speaks volumes in a positive fashion about their character and loyalty to their employees. And the four of us are just grateful to be a part of that dynamic. Anyway, today's webinar will cover the following topics within three general subject areas. The first major category is how to deal with COVID-related health issues in the workplace. Some of the issues we'll cover within that category. By way of example, what measures can employers take to determine if employees coming into the workplace have COVID-19 or related symptoms? Can employers tell their employees if a coworker contracts COVID-19? Or what are an employer's obligations with respect to granting requested accommodations to employees with disabilities who are at a greater risk of severe illness if they contract COVID-19? The second major category is planning for your PPP loan. Examples underneath that are, can employers furlough employees until the PPP loan comes in? Or how can employers apply for a PPP loan? Or how can employers deal with reductions in force and salary reductions in light of a PPP loan? The third major bucket, if I can call it that, is addressing unemployment insurance issues. For example, how do the new federal unemployment provisions work? Very importantly, what is the interplay between state and federal standards? What are the rates of unemployment under the new rules? And what do you do with employees who don't want to return to work? A couple of logistical issues before we move forward. As true with our other webinars and with regard to questions you may have, just by way of reminder, you can write them to us and we'll do our best to answer them during the program. Recognize, however, that there's a lot of material to cover and we may not get a chance to answer all questions that are posed to us. So it's true with past webinars that we've been conducting. If you have further questions that we can't get to answer today, please either email Laura, Mary Ann, Sal, or me alternate dates and times and half-hour blocks when you're available to speak by telephone, and we'll arrange appointments to help walk you through the issues. Given the intensity of the calls we've been receiving over the last week or two, three, we'll set up appointments with existing firm clients first, but we'll get to everybody as we've been doing. And lastly, slides and a copy of the video will be made available to you either later this afternoon or tomorrow, and those will be sent to you automatically. With that behind us now, we'll move forward to the next slide on a substantive level.
Hi, everyone. This is Lauren Levine. I hope everyone's doing well and staying safe in these challenging times. The first substantive slide we're going to talk about is some of the additional guidance that has come out from the Department of Labor, first in their frequently asked questions, and then in the final paid leave rule for the FCRA. It's important to note, I'm sure many of you are hearing this, that the Department of Labor is coming out with guidance at a very quick pace, more than we've ever seen, and in fact, sometimes they are changing the guidance. So it's important to know at any juncture what the Department of Labor is saying about these issues, under the FCRA at any time before making any employment decisions. Before we talk about the specific updates and guidance that are out there, just a quick reminder of what the FCRA is. This is the Families First Coronavirus Act, and this provides employees under certain circumstances with emergency sick leave and expanded FMLA leave for COVID-related reasons. Now, bear in mind also that New York State has their own paid sick leave rule related to coronavirus, and there are other considerations in New Jersey and Connecticut as well. But the federal rule that we're going to be talking about, just as a reminder, the sick leave portion, the entire law applies to employers with fewer than 500 employees, went into effect on April 1st and will last until the end of 2020 unless extended. And there are two components, the extended sick leave and the extended FMLA. There's also, and many of you have been asking questions, and we will get to this in a little while. There is an exception. Healthcare providers may opt out, healthcare entities may opt out for their employees who are healthcare providers and first responders. This is pretty much everyone, as we all know now, working for healthcare entities. The DOL has provided guidance saying that. Andrew Zwerling will talk in a little bit about how to opt out, how that opt-out works, and what the guidance is out there on how that piece of this program works. But as far as the sick leave goes, that's sick leave for all employees. It's up to 80 hours, 2 weeks of paid sick leave under the FCRA. There is no waiting period for employees to get that time. If they're employed currently, they will be eligible. And that sick leave can only be used once, so it can't be taken more than one time. Under the sick leave, employers are required to provide full pay, capped at $511 per day, with an aggregate cap of $5,111 per employee. To the extent that an employee is unable to work or can't telework due to certain enumerated reasons, and that's the employee is subject to a federal, state, or local quarantine or isolation order related to coronavirus. The employee has been advised by a healthcare provider to self-quarantine due to concerns related to coronavirus, or the employee is experiencing symptoms of coronavirus and seeking a medical diagnosis. Now, that's full-time employees as well as part-time, and part-time employees will get paid for the days they were supposed to work during that period. There's also a provision for paid sick leave at 2/3 pay, capped at $200 per day and $2,000 in the aggregate, for those who need to be off of work because they're caring for an individual who's subject to a coronavirus quarantine or isolation order, or that individual is experiencing coronavirus symptoms, or the employee is caring for a child if their place of care, their daycare, their school is closed due to coronavirus precautions, or if the employee is experiencing any other similar conditions related to coronavirus. Importantly, you cannot require employees to use other paid leave before the emergency sick leave portion of the FCRA. Now, as I mentioned, and as you all know, there's also extended FMLA leave for under the FCRA, and this allows 12 weeks, up to 12 weeks of leave for designated coronavirus reasons. And this applies to employees who have been employed for 30 calendar days or more. So many of you who deal with FMLA issues on a regular basis know that there is a 1-year requirement and 1,250 hours generally for an employee to take family medical leave. That is not the case for the coronavirus portion, at least not the extended coronavirus, the FMLA under the FCRA. However, if you have someone who's taking regular FMLA for an actual illness, those rules would still apply. And again, this is for employees only, for employees who are unable to work or telework due to a need to leave for childcare, where they're taking care of a son or daughter under 8 years of age, because their school or childcare has been closed due to the public health emergency. Now, under the FMLA extended leave, the first 2 weeks can be unpaid, but employees can elect to use other paid benefits to cover that 2 weeks. And the remaining 10 weeks are at 2/3 of the employee's regular rate of pay, capped at $200 per day and $10,000 in the aggregate. And this is job protected leave. There are certain narrow exceptions for employers with fewer than 25 employees, but for the most part, this really provides job protected leave, both the sick leave and the FMLA. So now that we've discussed the basics, just so everyone has some context, I want to talk a little bit about, back to the last slide. I want to talk a little bit about some of the DOL guidance that's out there on questions that we have been receiving. Now, one of the things many people have noticed is that the amount that the employees will be paid under both the sick leave and the FMLA extension is less than many people make regularly for their full salary. So the Department of Labor has said for the first 2 weeks of unpaid family medical leave that employers and employees may agree to allow employees to use pre-existing paid leave to cover the remainder of their salary, to cap them off, to top them off, to allow them to collect their full salary for that period, which makes a lot of sense to allow employers and employees to agree to this because of the low caps. Now, after the first 2 work weeks, after the 10 days of expanded family and medical leave, this is important. A lot of employers have been asking, can we require employees to take other leave that we generally offer the way that we would require concurrent leave under regular FMLA? And the answer now, the DOL has said very clearly, you may require your employees to take concurrent leave for a family medical leave extension, as well as your existing leave that you have under your policies. And that would include personal leave, paid time off, things of that nature. It would not include medical or sick leave if your employee is taking off for the extended FMLA and they're home to care for a child. Your sick leave wouldn't cover that, but you can certainly require them to take PTO or other paid time off that they have in their bank that is not sick time. The DOL has also expanded the definition of children under the statute. The FCRA actually says you need to be home to care for a child who's under 18 years old because their school or child care provider has closed. In the final rule, the DOL has said that the law also covers children who are over 18 but have a physical or mental disability that requires care that isn't available because of COVID. So they did expand the rule to include that group so that that population is taken care of as well. They did, however, on the flip side, narrow the definition of individual. The law says that workers may qualify for sick leave to take care of an individual who's affected by COVID-19. And the regulation makes clear now that an individual under those circumstances is a family member, someone residing in the same household, or someone else with that level of personal relationship that there would be an expectation that the employee would be required to care for that individual. So I think that, there's a lot of people that were, trying to take the leave for just say, oh, I have to take care of my friend or I have to take care of whomever. So they made very clear that this is really an individual who you have a close relationship with, and we would expect that you'd be taking care of them. We also got many questions about whether employers would have to pay the sick leave and the extended FMLA to furloughed employees. I know a lot of employers were concerned about that. The Department of Labor now has clarified that workers are not eligible for any of these leave options for any period where their employer is closed. And that's regardless of whether you're closed due to lack of business or because you're closed because of an order by public officials, like a stay-at-home, a shelter-in-place order. There was some confusion about that because the statute defines quarantine to include those people who are in a shelter-in-place order, but the DOL has very clearly said now, if you are home because there's due to a lack of business, then or by the order of public officials, then the employees will not be entitled to this leave. There's been some clarification in the Q&A that the reason that shelter in place or stay-at-home orders were included in that quarantine is because there are some employers who may have essential and non-essential workers, or may have employees in some states that can work and employees in others that can't. So that's why the shelter in place was included in the FFCRA, but they have now made very clear that if your business is closed because of one of these orders, your employees will not be entitled to those leave options. The Department of Labor, and we had said this on our previous webinar, but I think it bears repeating, the final rule and the frequently asked questions, the Department of Labor has made very clear that the emergency FEMA leave is not separate from the 12 weeks of FMLA time workers usually get under normal circumstances to bond with a newborn child or for health reasons. So if you have an employee who's already taken FMLA leave for whatever reason, they're not going to be entitled to the full 12 weeks depending on how much they took already. And if employees are already out on FMLA, that time is unpaid, whereas this new expanded FMLA is paid. And that may be a difficult thing to address as an employer because employees in similar circumstances, some may be getting paid and some may not. But the DOL has made very clear that you're not entitled to more than 12 weeks total, either including the expanded FMLA. Now, some employers may want to pay employees who have already used their FMLA pursuant to the expanded rule now for someone who may have already taken time for a healthcare issue or to bond with a newborn child and is technically out of FMLA time, but now needs to be home to take care of a child. And if there are employers that can afford that and want to do that, then that's absolutely fine. But you should be aware that you will not get the tax credit, and we'll talk a little bit later about that, but you will not get the tax credit for those employees where you're paying them expanded FMLA that they were not actually entitled to. Another question we've been getting a lot is about the intermittent use of the sick leave and the FMLA expansion. Generally speaking, FMLA can be used intermittently. Employers and employees can agree how that works and what hours it can be used for. The DOL now says absolutely that you can agree to use the sick and expanded FMLA for child care purposes intermittently. And again, that's only for the child care purposes, because the other provisions where we don't want people coming in because they're actually sick, those wouldn't be used intermittently because that's for people who can't work because they're sick and can't telework. So this would only be intermittent use if you're taking the expanded FMLA or sick leave for child care purposes. And again, the rule has also explained employers can make workers take accrued vacation or other PTO at the same time they're taking a leave to care for a child, including if they're taking it intermittently. Next slide.
We'd like to address certain issues that were raised by a number of healthcare clients in anticipation of today's webinar. Specifically, what is the scope and breadth of the healthcare provider exemption under the FFCRA? As a reminder, under that exemption, and as Lauren pointed out earlier, an employer of a healthcare provider or an emergency responder may elect to exclude such employee from the application of the paid sick and paid family leave requirements. This topic was elaborated on and clarified somewhat, not entirely, by the Department of Labor in a temporary rule on April 6th, 2020. The first question, obviously, is who constitutes a healthcare provider? And the Department of Labor specified that for purposes of employees who may be exempted from the emergency leave benefits under the FFCRA, a healthcare provider is anyone employed at, and then there's a laundry list of entities, at any doctor's office, hospital, healthcare center, clinic, post-secondary educational institution offering healthcare instruction, medical school, local health department or agency, nursing facility, retirement facility, nursing home, home health care provider, any facility that performs lab or medical testing, pharmacy, or any similar institution. And as the Department of Labor added, the definition also includes any individual employed by an entity that contracts with any of these institutions that I just described to provide services or to maintain the operation of the facility where that individual services support the operation of the facility. So as the Department of Labor also made plain and specified that definition is broader than the one that we're used to for the term healthcare provider under FMLA, which includes licensed doctors of medicine or osteopathy and any other person determined by the department to be capable of providing healthcare services. That definition was more narrowly defined to mean medical professionals who are capable of diagnosing serious health conditions in light of the FMLA requirement for those healthcare providers to issue certifications regarding the nature and probable duration of serious health conditions. The term healthcare provider in the FCRA, however, is not limited to diagnosing medical professionals. As I mentioned, it's that laundry list of individuals and anyone employed at those entities. And so it's not only going to include medical professionals, but it's also going to include other workers who are needed to keep hospitals and similar healthcare facilities well supplied and operational. So with that broad definition in mind, the next question then becomes, how is that exemption to be applied? And importantly, by the use of the word may in the exemption, it's clear that the exemption is permissive, not mandatory. An employer of healthcare employees can decide to pay its employees the benefits under the FCRA. And Mary Ann, Sal, Lauren, and myself have dealt with quite a number of healthcare clients who are doing just that. So there is a freedom of choice. It's not a mandate, the exemption. You can decide to opt in or decide not to opt in. The next issue then becomes whether an employer is required to exempt everyone or no one under the codified law. And the answer appears to be that it is not an all or nothing exemption. In fact, the Department of Labor expressly stated in terms of the scope of the exemption, and this is a quote, to minimize the spread of the virus associated with COVID-19, the department encourages employers to be judicious when using this definition to exempt healthcare providers from the provisions of the FCRA, unquote. Now, although the term judicious is not defined, this phrase makes it apparent that an employer can be selective about who is or isn't subject to the exemption. You can pick and choose in your judgment. And the apparent objective of the Department of Labor through the use of this language is to send the message. Don't bring in employees you don't have to. Let those who are not necessary for operational viability or necessary to support the operation of your facility to stay home and receive the benefits. That said, we strongly recommend, as we've been doing for a bunch of weeks now, that should you as an employer decide in your discretion to only partially apply the exemption, that you ensure you do so in a non-discriminatory fashion. And just as importantly, that you document the reasons why certain individuals you permitted to fall outside of the exemption or have clear guidelines as to your decision. For example, you may decide to exclude from the exemption certain job titles that are not essential to the operation of your entity. Maybe, front desk receptionist you don't need right now. Okay, you can do it by title. And again, that's just an illustrative example. Whatever your rationale, document it and engage in a comparative approach to ensure that you're not unfairly or wrongfully treating employees who fall within the exemption. Next slide. How to handle COVID-19 concerns at the workplace. That first question, what measures can employers take to determine if employees coming into the workplace have COVID-19 or related symptoms? This is a critical question to answer as the economy starts or is about to start to open up. And as the EEOC has explained, that at the present time, the COVID-19 pandemic permits an employer to take the temperature of employees who are coming into the workplace. Employers may also ask all employees who will be physically entering the workplace if they have COVID-19 or symptoms associated with COVID-19, or ask if they have been tested for COVID-19. And the symptoms associated with COVID-19, as many of us know by now, include, for example, cough, sore throat, fever, chills, shortness of breath. And an employer may exclude those with COVID-19 or symptoms associated with COVID-19 from the workplace because, as the EEOC has stated, their presence would pose a direct threat to health or safety. Also, to state what should be obvious, but it's always worth stating that anyway, For those employees who are teleworking, however, they're not interacting physically with coworkers, and therefore the employer would generally not be permitted to ask those questions because they simply don't pose that same health and safety risk. A caveat about singling out particular employees to ask these questions instead of asking all employees. If an employer wishes to ask only a particular employee to answer such questions or to have his or her temperature taken, the ADA requires the employee to have a reasonable belief based on objective evidence that this person might have the disease. So it's important for you as an employer to consider why you wish to take these actions regarding a particular employee as opposed to across the board. So, for example, if an employee notices that an employee has a persistent hacking cough, it could ask about the cough, whether the employee has been to a doctor, and whether the employee knows if he or she might have COVID-19. The reason these types of questions are permissible now, at this time, is because this type of cough is one of the symptoms associated with COVID-19. Just by way of the example of a not to. On the other hand, if an employee notices that an employee simply seems to be distracted, then that would not be a sufficient basis to ask whether that employee has COVID-19. Okay, next question. What can employers do if an employee refuses to cooperate? The employee says, nope, you're not taking my temperature, I'm not answering your questions. You as an employer may bar an employee from physical presence in the workplace if he or she refuses to cooperate, simply stated. That said, to gain the cooperation of employees, you may wish to ask the reasons for the employee's refusal. You may be able to provide reassurance as an employer that you're taking these steps to ensure the safety of everyone in the workplace, even in that individual. Try and feel them out to see why they may be resisting, and sometimes that can do the trick. Because sometimes employees are reluctant to provide medical information because they fear an employee may widely spread such personal medical information, or there might be some negative consequence attendant to it. And you may, in order to induce their cooperation, put those fears to rest with some easy explanation. Third, may an employer require employees reporting to the workplace to wear face masks? Governor Cuomo has ordered businesses that are still open in New York to give employees who interact with customers masks or other face shields to prevent the further spread of COVID-19. And for all essential businesses or entities, any employees who are present in the workplace must be provided and must wear face coverings when in direct contact with other people or members of the public. And the businesses, importantly, must provide at their expense face coverings for their employees. This mandate of the governor took effect on April 15th and is going to remain in place until May 12th unless otherwise extended. What can employers do if a worker comes in with COVID-19 or related symptoms? In addition to excluding the employees from the workplace, a designated representative of the employer may interview the employee to get a list of people with whom the employee possibly had contact through the workplace, so the employee can notify those who may have come into contact with the employee, importantly, without disclosing the employee's name. Because you must keep all medical information, even if it's not a disability, confidential. This is in addition to some other pragmatic steps you would take as an employer, which would include enhanced cleaning and other precautionary measures. Now, suppose a manager learns and confirms that an employee has COVID-19 or has symptoms associated with the disease. Now, most managers are going to know they have to report it, but they're also going to be worried about violating ADA confidentiality. What should the manager do? And the answer to that question is that the ADA requires that an employee keep all medical information about employees confidential, even if that information is not about a disability. Clearly here, the information that an employee has symptoms of or diagnosis of COVID-19 is medical information, but the fact that this is medical information does not prevent the manager from reporting it to appropriate employer officials going up the chain so they can take actions consistent with guidance from the CDC and other public health authorities. The question really is, what information do you report? Is it the fact that an employee unnamed has symptoms of COVID-19 or a diagnosis, or is it the identity of that employee? And the answer is that exactly who in the organization needs to know the identity of the employee will really depend on each workplace and why that specific official needs the information. employers should make every effort within those guidelines to limit the number of people who get to know the name of the employee. Now, certainly, as we've said, a designated representative of the employer may interview the employee to get a list of people with whom the employee possibly had contact through the workplace, so that the employer can then take action to notify those who may have come into contact with the employee. However, and this is important, this does not require disclosing the employee's name. Now, when we've had these discussions with clients in these last few weeks, a bunch have said, well, we're a small place, they're going to figure it out. True, for small employers, coworkers might be able to figure out who the employee is, but you as the employer are still in that situation prohibited from confirming or revealing the employee's identity. And we also remember that all employer officials who are designated as needing to know the identity of an employee should be specifically instructed that they must maintain the confidentiality of this information. And in fact, employers may want to plan what supervisors and managers should do if this situation arises and determine it in advance who will be responsible for receiving information and taking next steps. Last question on this slide that we've seen again a bunch of times. May an employer ask an employee who is physically coming into the workplace whether they have family members who have COVID-19 or related symptoms? Now, from a public health perspective, only asking an employee about his contact with family members really unduly restricts the possible extent of that employee's potential exposure to COVID-19. So the better question to ask is whether that person has had contact with anybody who the employee knows who has been diagnosed with COVID-19 or may have symptoms associated with the disease. And from an EEOC perspective, this general question is more sound because the Genetic Information Non-Discrimination Act prohibits employers from asking employees medical questions about family members. Next slide, please.
Just to follow up on the confidentiality issues here that Andrew already has touched on, we all know our employees are concerned about this pandemic. Of course, they're concerned for themselves, they're concerned for their coworkers, and they want information. But we all need to remember that there are these ADA confidentiality restrictions that Andy just spoke about. Both the EEOC and CDC have said you need to operate within those confines. So just a few more questions that we've been getting that we thought would be helpful to answer about this confidentiality restriction. So what if you have an employee who's working from home because they have COVID-related symptoms? Can you tell your staff that that's why they're working from home? The answer to that is no, you may not tell them. You can tell the staff if they need to contact that employee how to get in touch with them and that they're not present in the workplace, but you absolutely cannot disclose that they are home due to COVID-related reasons. If the employee was on leave rather than teleworking because they had COVID-19 symptoms or any other medical condition, then of course, too, you can't disclose the reason for that leave. All you can say is, that person is on leave right now, so that anybody who will normally work with them and may want to come into contact with them understands that they are out on leave. But you certainly cannot disclose that it is for a COVID-related reason. The next question we've seen a lot is, may an employer tell the workforce the identity of an employee who has contracted COVID-19? And I think Andy already covered that, but it's really important to reinforce that the ADA does not permit such a broad disclosure of the medical condition of one of your specific employees, and it's also not recommended by the CDC. You do need to maintain confidentiality. Obviously, it's important to let employees know if they've come into contact, if they've been exposed, but there are ways to do that without disclosing the individual's name. Now, I think Andy said this already too. You may be a smaller employer where people are going to figure it out anyway. That's fine. It's still your obligation, though, as the employer not to disclose the individual's name and keep that confidential. Another question, may an employee who is reporting to the workplace disclose to a supervisor that a coworker who's also reporting to that same workplace has symptoms? So not only do we already hear from Andy that managers may disclose, but yes, a coworker who identifies that one of their coworkers has symptoms may absolutely bring that to their supervisor or their manager so that the employer can look into it and address the situation. It's not an ADA confidentiality violation for an employee to let their supervisor know that their coworker has symptoms. And then, it's important because of these restrictions that you should have in place what process will be followed if someone comes to you and says this person has symptoms, we're concerned. You should have a plan in place for what those next steps are, who the supervisors are that are responsible for addressing this, and who in the organization will be addressing the individual who has the symptoms to find out, what's going on and who they've come into contact with. So you do want to have something in place, a process in place to address those concerns. Now, may an employer notify public health authorities if they learn an employee has COVID-19? And the answer to that question is also yes. The ADA does permit this notification to public health authorities because, as the EEOC has explained in its updated pandemic publication, COVID-19 at this time poses a direct threat both to individuals with the disease and those with whom they come into contact. And the direct threat, the definition means that an individual's medical condition, in this case COVID-19, poses a significant risk of substantial harm to himself or herself or others. So the answer is absolutely, you should be letting the public health authorities know if you have a positive case in your workplace. And there are obviously other precautions you need to take in terms of cleaning and identifying who else came into contact. But certainly you should be letting your public health authority, your local public health authority, know about the confirmed case. Another consideration on confidentiality is once you do have these employees who have a positive test, this is medical information that's confidential, and many of us are working from home, including managers and supervisors who may be required to maintain that information in the employee's file. To the extent that you can, the EEOC has said you should follow your normal procedures for keeping medical information confidential. Your employees' medical information should be stored separately from regular personnel files. If you can follow your normal protocols while working from home to make sure that that happens, then absolutely that's what should be happening. If you can, and you have supervisors and managers who have to keep this information separately at home and then bring it when they go back to the workplace, you need to make sure that if they're storing it electronically, it's secure, and that you follow your normal protocols as soon as you can. Just one thing to keep in mind, the last couple slides we talked about pandemic guidance. These are all the answers that the EEOC is giving currently in the current state that we're in and the level of the COVID-19 crisis. But it's important, just like I said earlier on the DOL guidance, that we need to constantly be checking and keeping up on the EEOC guidance, because at some point they're hopeful that things will go back to the way they were, and a lot of these rules will change, and you will have less flexibility in addressing your workers' medical conditions than you do right now. Next slide.
Just two quick points before going through this slide. One of the questions asked, a very important question, is how do healthcare providers opt out or exempt themselves? And the short answer is there's no formal process. There's no interaction with the government necessary to accomplish that. You don't need permission. It's in your discretion. Simply, but importantly, document what your approach will be. So you have something memorialized if somebody looks back on it at some subsequent time and calls it into question. Another quick question that was asked is, can I require employees from another workplace or another employee who work in my workplace to submit to taking temperature and wearing a mask, even if their employee does not require such measures? The short answer is absolutely. The law permits you to take those actions, so you're free to do so. And with regard to the masks, quite frankly, in light of the recent order of Governor Cuomo, it's something that's required across the board. Okay, moving on to the questions on this particular slide. With regard to that first question, what are an employer's obligations when an employee says that he or she has a disability that puts him or her at greater risk of severe illness if he or she contracts COVID-19 and therefore asks for a reasonable accommodation? And there are, as identified by the CDC, a number of medical conditions. Chronic lung disease, serious heart conditions have been identified as potentially putting individuals at higher risk. This should be treated as a request for a reasonable accommodation, meaning it's a request for a change in the workplace due to a medical condition. And therefore, what you want to do at that juncture, if you're confronted by that, once you verify the existence of the disability and discuss, why an accommodation is needed and the type of accommodation that would meet the employee's health concerns, then you make a decision there what you should or shouldn't do. You need to have that interactive dialogue with the employee as you would and should in any situation where a reasonable accommodation is requested. You may also, in having that dialogue, consider whether a reasonable accommodation would pose an undue hardship to you as an employer, meaning you as an employee may assess whether a specific form of accommodation would pose significant expense or significant difficulty. Given the demands, and this is just a practical point, on the healthcare system due to the current crisis, employers seeking documentation from a healthcare provider to support the employee's request should really recognize that because of the health crisis, many doctors may have difficulty getting back to you quick with documentation that you would otherwise require under normal circumstances. But there may be other ways to verify the existence of disability. So, for example, a health insurance record or a prescription may document the existence of a disability. And if you as an employer is waiting to receive documentation, you may want to provide that accommodation on a temporary basis. Again, these are just different ways to approach it given the crisis. And this could be particularly critical where the request is for telework or leave from an employee whose disability puts them at higher risk for COVID-19 or from COVID-19. Next question, what are an employee's ADA obligations to provide reasonable accommodation if an employee says that he or she lives in the same household as someone who, due to a disability, is at greater risk of severe illness if he or she contracts COVID-19? We've had this question many times already. The employee only has a right to reasonable accommodation for his or her own disability. In the situation raised in this question, the employee does not have a disability, only a member of his or her household does. The employer should consider, however, if it is treating the employee differently than other employees with a similar need before it responds to the request. Meaning, again, if you're going to make an exception for one employee, you got to do it across the board because you otherwise may face the risk of being accused of acting in a discriminatory fashion. So as we said before, engage in that, comparative assessment before you say yes or no in a given situation. Next question, may an employer exclude from the workplace an employee who's 65 years or older who does not have COVID-19 or related symptoms solely because the CDC has identified this age group as being at a higher risk of severe illness from COVID-19? The answer is no. The Age Discrimination and Employment Act forbids employment discrimination against workers age 40 or over. So if the reason for an action is older age, over the age of 40, the law would not permit employees to bar older workers from the workplace, to require them to telework, or to place them on involuntary leave. One way to show that an action was based on age would be if the employer did not take similar actions against comparable workers who are under the age of 40. So steer away from that. The same considerations apply to every protected group, for example, pregnancy and national origin. They may not be treated differently just because they're a member of that group. Next question up, is an employer required to grant a request to telework from an employee who is 65 years or older because the CDC says older people are more likely to experience severe symptoms if they get COVID-19? Again, the answer is no. However, once again, if an employer is allowing other comparable workers to telework, it should make sure that it is not treating older workers differently based upon their age or, again, any other protected characteristics. Next slide.
So the next slide here is considerations regarding employees working from home. I'm going to go through this quickly because we still have a number of substantive topics to get to. But these are some things you should think about if you do have employees working from home at this time. For non-exempt employees, timekeeping, off-the-clock work, meal and rest breaks, and overtime, these are things you have to consider. If you have policies in place already that can be transferred to employees working from home, that's fine. But let's say you have a time clock at the office where they normally need to punch in and punch out for these time periods. You need to address that and make sure that employees are keeping track of their time and that you have that being done in a consistent manner. And also with respect to overtime, that employees are aware that they must be authorized to work overtime just like they would be under normal circumstances, and that you have something in place to make sure that these things are happening. Another question we've seen a lot, and there's questions here for sure, for non-exempt and exempt employees working from home, expense reimbursement. Generally speaking, if you have employees working from home, there'll be some agreement as to what the employer is required to pay for and reimburse them for. A lot of times the equipment would belong to the employer, or you'd have some sort of hybrid. But here everybody's working from home, or most people working from home are sharing their office supplies and their internet and whatever else they're using with other family members, children, spouses who are also working. So there are certainly questions about how that will be divided and what reimbursement will look like for employees working from home. And those are just things for you to consider to the extent that you do get requests for reimbursement. Next slide.
All right, good afternoon, everyone. This is Mary Ann Monroy. So the next topic is going to really cover workers' compensation and unemployment. Given the time, I too will go through this a little bit more quickly, and feel free to give us a call if you have any more detailed questions. So one of the things that we get calls about relates to, well, I have an employee who is sick. Now what do I do? Are they entitled to workers' comp? Now, first you have to look at, well, do they get sick leave benefit? Well, under the Federal Act, or maybe it's your own PTO policies, or for instance, New York has a sick leave policy. So employees would be able to get that type of sick leave, potentially disability, paid family leave. But as far as workers' comp, there isn't really case law yet on the issue of COVID-19, contracting COVID-19 at the workplace. It will likely be fairly controversial. Insurance carriers aren't going to be quick to pay out claims absent showing a real on-the-job exposure and that the employee contracted COVID-19 at the job. And that could be fairly difficult to establish. Typically, workers' comp claims come in two varieties, such as occupational disease or accidents. Historically, the occupational disease type of claim relates to you have a particular job that proposes a special type of hazard. Healthcare workers, for example, have typically been able to get workers' comp under occupational disease theory for TB exposure. Otherwise, most employees will claim workers' comp for an accident type of thing. They got hurt on the job. And for establishing an accident, you need to show a connection between the injury or the condition and a specific event that happened at work. So that's what is going to have to happen most likely for workers' comp related to contracting COVID. And with it being such a widespread pandemic, can an employee really show that they got COVID-19 at the workplace versus when they went to the grocery store or they went to the pharmacy or ran whatever other kind of errand? So, there were certain types of jobs where it may be easier to prove, whether you're a healthcare worker or you're in an office that had a cluster of cases. Those might be easier to establish a workers' comp claim. Types of benefits include medical expenses, lost wages, death benefit, in some instances for the surviving family members or spouse. States have specific structures regarding workers' compensation benefits. Often there are waiting periods. For instance, in New York, it's 7 days. The other thing to keep in mind, this workers' comp covers employees, not independent contractors. So I would suspect that there might be independent contractors who may claim workers' comp and call into question their classification, whether or not they were properly classified as independent contractors versus employees, which would have entitled them to the benefit. So I do think that there could be some possibility of litigation in that area. So as far as employment, I want to move to the next slide. Okay, so the states offer unemployment benefits, and then we're going to talk about the new federal component or counterpart to that. So regular unemployment, there is a general standard that the worker must be ready, able, and willing to provide work, okay? And that standard generally still applies. Now, given the DOL is inundated with claims, perhaps there's a little bit less scrutiny there. But if an employee says, look, I just want to stay home, I'm too afraid to come to work, that should not in and of itself allow an employee to collect regular unemployment benefits. Now, if there's a reason that's covered under the federal law as to why they just don't want to come to work, that might qualify them, and we'll talk about them next. But let's work first under the premise that there's still a ready, able, and willing to work standard. Sometimes employees may have reasons that they're disabled or they have a compromised immune system, and reasonable accommodations may include leave, whether it's sick leave or family leave, paid family leave, then that could affect the ability to get the unemployment. All right, so you can't be on a paid family leave or paid sick leave and still collect unemployment at the same time. All right, so next slide. All right, so eligibility issues. The easiest scenario, frankly, is if you lay someone off entirely, furlough them, terminate them, that person will be able to collect unemployment, assuming that they've worked the minimum amount of time to collect unemployment. And there's a formula that's usually involved. If they only worked one day in their life before COVID-19 hit, they might not be eligible for state benefits. The other scenario is partial unemployment because the employee has had a reduction in hours or reduction in their schedule. Those employees may also be eligible for benefits, not at the full rate, but partially. So for instance, in New York, the employee has to work less than 4 days and earn less than the unemployment maximum of $504 per week. And for each day that they work over 3 days, or for each day they work during the work week, there's going to be a reduction of their unemployment benefit, all right? So in a lot of cases, working partially is financially less. You make more money being totally laid off in many cases than working partially, although some employers may feel like, well, if I give them half their hours, 20 hours a week, that's got to be better. It's not necessarily going to be better in this scenario. And we have helped clients crunch the numbers in that case to determine what would be best for employees. All right. So, for instance, New Jersey also allows for a reduced weekly benefit based upon a reduction in their work schedule, but it's offset any amount earned in excess of 20% of the maximum weekly benefit. There's a dollar for dollar reduction. The other thing to keep in mind that the states, New York, Connecticut, New Jersey, offer a shared work program. So if an employee is working part-time, but they still earn a certain amount of money or work a certain amount of hours that disqualify them under typical unemployment benefits, they may still be able to get partial unemployment, regular unemployment insurance, if their employer applies for this shared work program. Basically, it's an alternative or an incentive to not laying people off. And it allows employees who earn in excess of the minimums or the maximum amounts to still get partial unemployment. So that might be an option that many of our clients, and I know some of our clients have considered, have already applied for. All right, next slide. Okay. All right, so now if unemployment, regular unemployment is not available for some of the reasons we just talked about, there is still relief available under the Federal CARES Act for employees in the way of 3 different programs. So the first one is pandemic unemployment assistance. So essentially, if you aren't qualified for unemployment, regular unemployment, you may still be able to get unemployment under this program. It's a temporary benefit. It goes through December 31st of this year, and it can run for up to 39 weeks. And it applies to those who are able and available to work, but for some of the reasons set forth in the law, and there are 10 different reasons related to COVID-19. So, for example, well, I would be able to go to work, but I've been diagnosed with COVID-19. Or I would be able to go to work, but my healthcare provider told me to quarantine. Or I'm the primary caregiver for my child and my school is closed. Now, those are all going to be reasons now that an employee can get unemployment, all right? So we've even seen things where if the employee is now had their hours reduced drastically, and an excuse or a reason to get unemployment would be, look, I had to quit because my hours were reduced and it wasn't enough for me to, survive. And that's a direct result of COVID-19. That's going to qualify the person under the Pandemic Unemployment Assistance Program to get unemployment, okay? And there are a number of other reasons, such as the person has symptoms and they're seeking treatment or providing care to a family member. So keep in mind there are a whole bunch of reasons that this federal benefit now will kick in. Next slide. Okay. The covered individuals include those who are not otherwise, as I said before, eligible for the state benefits. It could be self-employed independent contractors, those without a sufficient work history, but it does not include employees who can telecommute, okay? Those people are ineligible. Same thing if you are collecting paid sick leave or unpaid family leave, those would not qualify the individual for unemployment. And the same holds true in the other direction. If you've already been laid off and you're on unemployment, you can't collect FMLA and other paid sick leave benefits, including those under the FCRA, okay? Next slide. Okay. So then you also have pandemic unemployment compensation. So that is the $600 benefit that everybody has been talking about. It's just starting to fund in New York, New Jersey, and Connecticut. I believe New Jersey is starting as well. In Connecticut, it will start this week. That is $600 a week until July 31st. And anyone who's collecting regular unemployment benefits or unemployment under the PUA will receive that $600. And it doesn't matter if it brings you above the pre-unemployment earning level. So again, for a lot of people, they may make more money on unemployment given the $600 additional benefit than they would normally before this pandemic. Okay, and then the other piece that the CARES Act provides for is the Pandemic Emergency Compensation Program. And so when all the money runs out and you're done with regular unemployment and you're done with the PUC, the $600, there is federal funding for yet an additional 13 weeks of unemployment that will get potentially workers through December 31st, 2020. And so really that's when you use everything else up. That's what will be available. So again, I went through that fairly quickly. If you have specific questions, feel free to write them in or give us a call. Next slide.
Okay. Thank you, Marianne, and thank you for everyone. We know we're pushing over our time here to the hour we had initially allotted, but as you can tell, there's a lot of important information that we're covering, and we are looking at the questions. As you've seen, most of those questions get answered just through the course of our presentation today, and we thank you for submitting those questions and all the questions we've received to date, because it helps guide us in terms of our additional research in these very novel times where the laws are changing daily, sometimes even hourly, it seems like, on our end, and we are able to stay up to date and ahead of the curve when we hear from our clients that are at the forefront of identifying these issues. We do have a little bit of time that I'm going to spend on the Paycheck Protection Program and some of the recent updates. I'm going to focus this mainly on two areas in terms of the forgiveness and related to what Marianne was just speaking about in terms of what do we do with staff who may not want to come back because they're getting more money on unemployment or for other reasons. We're not open yet, but we've been funded. So just a couple of things to touch on at an early stage. Applications. If you have already put your application in with your bank but did not receive funding because the funding ran out last week, most of the lenders we're speaking with are saying that they have you in line and that you would be eligible for the next round of funding. We are hopeful that Congress can get together today or tomorrow at the latest, and it may have already happened while we were on this webinar and preparing for it this morning, in which additional funding will be released. So please stay in touch with your lending institutions. We do know how important it is for you and the small businesses to get this funding in order to stay afloat and provide the necessary payroll costs your employees need. In terms of the approvals, you're not alone. If you tried to submit an application to a bank and didn't hear back or didn't get approved or didn't get funded, I'm going to overgeneralize here just for the sake of brevity, but some of the larger banking institutions did not have platforms set up, and they just were not equipped to get the programs in place. For example, we've heard some horror stories about Citibank, Capital One, Bank of America, where they just didn't have the platform set up. Keep following up with them. Hopefully things are in place and applications are being accepted on a going forward basis. For those that did receive approvals and either got funded already or will be getting funded, well, then we have to start talking about some of the next particular issues, which result in the reductions of the loan forgiveness. Because let's face it, most people were applying with the expectation that as long as they use the funds for payroll, the loan would be forgiven. So it would essentially be converted into a grant. And for the most part, if you use the funds for the permissible reasons, payroll costs, mortgage, interest, rent, and utilities, the amount that you do receive as a loan would be forgiven. However, what people are running into is, I've laid off staff or furloughed staff because my business is closed. My orthopedic practice, my dermatology practice, my manufacturing business is closed by the state. I can't do anything. I've laid people off. I've got the loan. Do I have to bring them back and pay them for no work in order to get their forgiveness? The conservative answer seems to be yes. And I'm hedging that because there has been some guidance in the last couple of weeks that suggests that if you, the second bullet point on this slide, if you bring folks back before June 30th, who you laid off between February 15th and April 26th, you can still get the forgiveness. We're waiting for additional guidance. The expectation is that by April 27th, SBA and the Treasury, or some combination, should have some final guidance. As you heard our prior speakers, Lauren and Andrew in particular, talk about, DOL came out with final guidance on a rolling basis and then some additional rules late in the game. And that provided a little bit more clarity in terms of what exactly employers are supposed to do. We're expecting the same thing. I know that does not provide much comfort for those of you, like a client of mine who got funded on a Friday afternoon and was not expecting it. And over the weekend, we were trying to figure out what's the best course of action. And again, the conservative approach is bring everybody back, bring them back to that salary threshold, which is talked about on this next slide, where you cannot reduce the salary below 25% compared to the most recent full quarter. Get them back to that payroll rate, get them back to that number of full-time employees so that you stand the best chance of not losing the forgiveness. That said, there may be situations where, again, if you're closed and you're a business that's closed and you're a healthcare provider, for example, and can't treat patients, or an ambulatory surgery center where you can't function or operate, that you might want to consider holding off for a couple of weeks, bringing people back, allow the staff to collect unemployment so you avoid the issues where some staff say, hey, I'm making $1,100 sitting at home in the comfort of my living room. Why would I come back or have to be on call and make $750? I have bills to pay. This isn't fair. Maybe there's some way you can crunch the numbers on your end to hold off, bring them back a little bit later, and then when you do bring them back, bring people back at their full rate, 100%, instead of the reduction of 25% or some other reductions that you may have contemplated. There may be a way for you to maximize the amount of forgiveness. That's not to say, though, that you would achieve the full forgiveness of the loan amount you've taken. One point I do want to make with that is that there is a reduction based on a 75% rule, meaning that the costs that you do make, 75% have to be allocated towards payroll costs. So whatever you do in trying to figure out how you're going to get to that maximum number, keep in mind that 75% of the cost must be allotted to your payroll. In other words, they don't want you paying your rent, even though your rent in New York City might be $40,000, $50,000, $60,000 a month. We'll put all the money towards rent and then we'll pay the leftovers for payroll. That's not the expectation of Treasury on this. You will lose the reduction. Again, we're hopeful that maybe there's some additional guidance coming out that would provide us with how we can allocate the funds and how we can keep employees unemployed, so to speak, and still be able to bring them back and get the benefit of the loan amount for payroll and the forgiveness on the back end, but that still is some days away right now. A few other questions that we've received quite frequently as I move across to some of the practical considerations are, what do I do if an employee doesn't want to come back? Well, the reality is if they don't want to come back, you can tell them that you have a job, it's available for you. If you don't come back, we're going to move on. And the reason you need to move on might be twofold. One is in order to achieve the forgiveness that you contemplated when you submitted for the loan. And two, you might need the staff to work and help and provide guidance. So then they would have to fall back to whatever provisions might be available under unemployment. The other big question is, well, let's say I get the PPP loan, but I don't use all the money because, quite frankly, some employees didn't come back. I had no need for other employees because I'm a restaurant and I'm still closed. Nobody wants to come in, so why do I need wait staff? What am I going to do with this money? Well, then you have two options at the end of that 8-week period that the loan covers. One is return the money or return the portion of the funds that you did not use for payroll or the other eligible costs. Or two, keep the money, wait, use it for payroll costs and other expenses when you do reopen, but you're going to have to pay it back at the interest rate, which is 1%. It's deferred for 6 months and it's payable back over a 2-year period. Some people we've spoken to have said from an accounting standpoint, well, you know what, that makes sense. When else am I going to get a loan that'll help me pay for payroll going forward at such a low rate? Keep in mind, though, when doing that, there are some eligibility requirements that are covered. And again, we can go over these with you if you have specific questions, but this does have to be made in good faith. You have to affirm that it's because you expect a downturn in your business to some degree. So if you're flourishing and doing great and you think you're just going to be able to get a loan at 1%, the lender might look twice at the following year your records and revenue to determine that's not the case, and you might lose some forgiveness, or there might be additional penalties that can be incurred for any fraudulent conduct. So again, I know this is a lot of information that we covered in a very short period of time, but we do understand that other folks do have other obligations to get to today. And again, please email or call us with questions. You have a screenshot now of our emails and our phone numbers. We are returning calls and responding to emails. Sometimes it could be a very quick response to some of the questions, especially some of the questions that we're seeing come in today. We hope this was very helpful for you. We, again, appreciate all your time and feedback. And most importantly, we do appreciate all of your patience. We know it's difficult to get back to everybody, and sometimes it takes us a few hours or maybe even a day. And believe us, it's not for a lack of trying or commitment. It's just there are a number of calls that we're responding to. And quite frankly, sometimes the guidance just isn't out there, and it's taking additional time for us to circle back, contact our connections in the community, both the lenders on the PPP side, the Department of Labor. By way of just one example to some of the questions we're receiving with respect to, can owners apply? And I'm a sole proprietor, can I apply for unemployment? There was a question I saw with respect to sole proprietors applying for PPP. Yes, they can. And possibly they can also apply for unemployment. And the reason I say possibly is because it depends on what formula or you're using in terms of your wages. If you're a W-2 versus potentially a 1099 or some other distribution formula. By way of example, we called Department of Labor last week on that question, got a couple of different answers, and finally we're told, well, there's no real guidance. Put it in a cover letter that you're asking for unemployment and you're not sure because of the way you're paid and that you're an owner in a physician practice, for example. And that would at least allow you to get it, or maybe be rejected and not get it, but not have to worry about doing anything inappropriate where it would be considered fraud. So this is the kind of guidance we're getting from the Department of Labor, which of course makes it more difficult for you, but it at least provides some guidance in terms of what qualifications you might need and whether or not you are eligible. Before we conclude, is there anything else from the other panelists in terms of any other questions that might have come up that you want to address while I was speaking?
I'm good.
And there were a lot of
yes,
given the
I just see some questions at the end about the slides. The slides in the slide deck, I understand, will be may be available. You should receive an email following today's presentation with the recording and the slides. If you do not, reach out to any of us or your Garfunkel Wild attorney contact, and we'll make arrangements to make sure we can circulate that for you.
Sal, I do want to just address one question that we got because I think this is important. Not that they're not all important, but I think this is something that employers should know. One of the questions was, if the employees are already on unemployment, are they still eligible for FFCRA or FMLA? The extended sick leave and extended FMLA are not for employees who are furloughed or whose employers are closed. Those employees are eligible for unemployment, but they will not be eligible for the FFCRA leave. So I just wanted to clarify that.
And just one other point, I did see this question a couple of times about how do I document money for the PPP on payroll, or are there any best practices you recommend? What we've been recommending is, and as Andrew said in the earlier slides with respect to your general workplace policies, just document it the best you can. I know that's vague, so what we've said to be even more specific is consider opening up a separate checking account. Most of our clients work with some form of payroll company. Get in line with your payroll company. I'm working closely with several companies that I work with now to help not only educate them, but work with them and learn from them. I mean, they're a great resource for us as well. And one thing we've thought of is open up a separate account so you can directly track the payroll that you have. So that you get funded for $1 million, put that $1 million right into that account, and then have that go from your payroll company out paying your weekly or biweekly paychecks, whatever is required, to your staff. And then from that account, if you're going to write a payment for your rent under your lease, write the check out of that account now to the extent you can. I've gotten some pushback from clients and some banking institutions saying you don't have to do that. That's not what the law requires. You're absolutely correct. There's no requirement that you do that. It's just a suggestion if you can and if your bank's willing to work with you on that. Otherwise, just keep very, very detailed records. You're going to work with the lender. Hopefully you have a good relationship with the lender already. It's make it that much easier. You will be applying to that lender for forgiveness in the months after the loan is forgiven. We've heard all across the board that the application process for the forgiveness could be out till August or September. Others are suggesting that you can do it with your bank right away. Again, I would expect the same type of learning curve, growing pains with respect to your institution as when you got up and running. Those that had the program in place are probably going to be a little more equipped on the back end to help with the forgiveness.
This is Mary Ellen Roy. I saw one question that came in about if the person's laid off or furloughed, can I offer them a severance to pay their COBRA? Now, there are ways to go about that. First, I just wanted to point out if they're furloughed and not fully terminated, they may be able to stay on your health plan without having to go on COBRA. A lot of the health insurance carriers are allowing employees who are furloughed or just temporarily laid off to stay on their plans, whether it's through May or through June. So you might not need to deal with COBRA. Of course, you'll have to deal with trying to get the employee portion of the healthcare contribution. Some employers are just paying the healthcare premium altogether. If you fully terminated an employee and you want to enter into a separation agreement that allows that references payment of the COBRA benefit for a specified period of time, that can be done as well as part of a separation agreement, in which case we usually include some release language in it as well. So there are a lot of questions. We'll try to answer some of those after the program is over. But again, if you just email us, any one of us, we can also shoot you an email back with an answer. All right. I think any other questions do the panelists want to answer before we close for today?
Yes, I do see one other question about substituting the expanded, the sick leave during the extended FMLA for those 2 unpaid weeks. And the answer is yes, you can agree with your employee that they can use that paid leave to substitute for those first 2 weeks of unpaid leave, and obviously then they would run concurrently. If not, employees, the Department of Labor has said employees would be eligible for a total of 14 weeks taking both types of leave, but you can absolutely allow your employees to substitute those first 2 weeks with paid sick leave under the expanded FMLA.
And I do see some questions regarding how you can contact us if you don't have a relationship with us already regarding setting up the attorney-client relationship and with respect to fees. And we do not mean to be overly difficult or callous about this. We do need to have an attorney-client relationship for both malpractice reasons and also privilege. So we would ask, if they're not a client, that we engage in a formal relationship to provide specific legal advice and guidance. That said, we have gotten some one-off questions from folks who have attended just generally about the material that we've provided today in the slides or what we've said. In that sense, depending upon the nature of the question, we might be able to provide a little bit more guidance or direction to what we've previously disclosed already. However, for the more specific questions of I don't have people coming back, what should I do? What's a good resource for sending people notice? Unfortunately, in those situations, we do need to get engaged. It's for your protection as much as it is for ours. But because we've answered these questions probably 1,000 times in the last 3 to 4 weeks, those things can be answered very quickly with little or much attorney work and time. And the benefit on the back end, we think, is very helpful and beneficial to all of you. So we are entertaining and engaging in new clients and new dealings going forward. It's not just limited to healthcare. It's all other businesses, manufacturers, restaurants, construction, food banks, corporate, etc. But we are here for you, and we'll work with you no matter what the question is or the issue to get you to a place where you can feel comfortable. With that said, again, thank you all for staying on. Please look out for further updates and additional webinars and guidance that we will have. As we get the information, we will relay it both through Client Alert and these webinars. If you believe the webinars are extremely helpful to you or important, please let us know, provide any feedback, what you would like to see or what format. That way we'll continue to keep doing these. We don't want to do it if it's falling on deaf ears. We know you have enough to do already, but from the feedback we have received, it's all been positive. And again, we thank you very much. Best of luck. We'll leave you with this one thought to have. As people are bringing folks back, employees back, or telling them that they're going to be continued to be on furlough because the PPP didn't come through or funding's not there or we're closed till May 15. As part of your everyday employee engagement, it might be helpful to reach out and try to talk to your staff. Just check in on them, see how they're doing on a personal level. That will go a long way when this is all over on the back end of bringing people back and having them come back to a healthy and happy workplace in some sense. And your employees are going to be the best for you when they're in a good place and they know you care. So reaching out, sending emails, sending updates is definitely encouraged. You do not need to go overboard with telling them everything you've done, what bank you've applied with, how you've applied, what you've done to apply. Just let them know you're trying and you're working, and you'll keep them informed. So again, to everybody, stay healthy, stay safe, stay at home to the extent you can. We know many of you can't, and best of luck. Thank you so much for joining us, and have a great day.